Hello, my name is David White and I am one of the solicitors in BTO's Wills, Estates and Succession Plan Department. For most people, the idea of a will is understood and there's a general acceptance that they ought to put one in place. Yet, many will go through most of their lives putting this off, presuming that they won't be dying soon and they can deal with it when they have more money. But there are many reasons why a will is important, and you may wish to read some of our other blogs on these topics. Today, I thought it would be useful to chat about the key elements which are normally included in a will. These tend to be the decisions you will require to make before a will is drawn up for you by a lawyer, so it's useful to have a wee think about these ahead of your initial meeting. The first decision, and arguably the most important, is who should be appointed as your executor. The executor is the person responsible for the administration of your estate. This will involve identifying and gathering your assets, settling any tax or debts, and then distributing the remaining funds in accordance with your will. The executor is so important because if one is not appointed, your loved ones may need to apply to the court to have one selected for you following your death. This often prolongs the executory process and incurs further administration costs. The second main decision, and the one most people relate to a will, is who the beneficiaries will be. The beneficiary is the person or people that will inherit your estate after all debts and expenses have been settled. This can include family members, friends, charities or others in whatever way you wish. You can provide specific sums of money or specific items, known as legacies, or treat the estate funds as one big pot to be shared out. As part of the will, it's often useful to consider substitute beneficiaries in case the primary beneficiaries do not survive you or decline their inheritance. In addition, BTO styles ensure that any future informal writings that you put in place will be treated as forming part of your will. Therefore, if there are personal effects you wish to bequeath, but these wishes may change over time, you can keep an informal writing as up to date as you want. If you have young children, it's also extremely important to consider appointing a guardian for them. This guardian can become involved in looking after the child's welfare if you were to die whilst they are still of a young age. If you have particular preferences or wishes of how the children should be raised, you can also include additional commentary in a letter of wishes, which can be held with your will. Similar to the executor, if you die without appointing a guardian, an expensive and lengthy court process will follow to have a guardian put in place. Depending on your circumstances, it may be beneficial to also include trust provisions in your will. Although these types of wills are generally more expensive, the long-term advantages often outweigh any short-term additional cost. Trust can be used for a variety of purposes, such as for the protection of young children or beneficiaries with disabilities, or in circumstances involving a second marriage. This topic is discussed further in my recent blog if you'd like to check that out at btopersonal.co.uk. Trust provisions often include appointment of trustees to administer the trust in the future, and these can be the same people or different as those appointed as your executors. For some, it can be important to note any preferences in relation to funeral instructions. Although not legally binding, it is sensible to put these in writing if you do have strong preferences, and inclusion in a will is the most practical place for these. In recent times, it has become important to also appoint an individual to attend to your digital assets. I use that as an umbrella term for the folk more savvy than myself, who holds cryptocurrencies such as Bitcoin, but also digital content such as photos posted to Facebook or Instagram, music collections saved to the iCloud, or your TikTok account. These are some of the building blocks used by a lawyer in order to create a robust and efficient will for you. Alongside these elements, an initial meeting is also an opportunity for your lawyer to understand your specific circumstances, such as special types of assets, including pensions, joint, foreign or business assets, any inheritance tax implications, and any legal rights entitlements which may arise. Your lawyer should be able to advise on lifetime planning where required, and any other work which you may benefit from, such as a power of attorney. If you would like to put a will in place or feel it is time to review existing arrangements, please do not hesitate to get in touch with me at dwh@bto.co.uk and through our site at btopersonal.co.uk. Thanks for listening.